Can you see by the dawn's early light?
On the afternoon of September 10th, I arrived at a Utah hospital to do the unthinkable, to look directly at my husband's murdered body. That young man. I forgive him.
Welcome back to Court TV Live. Matt Johnson alongside my friend Kelly Craft in today for Ted and Julia. Busy day here. Let's begin this hour in the state of Utah, where the suspect in the Charlie Kirk assassination is due back in court today.
22-year-old Tyler Robinson is accused of murdering the conservative activist during a rally that was held at Utah Valley University. This took place earlier this month.
Robinson is expected to appear via Zoom during that hearing alongside his newly appointed defense attorney, where we're likely going to hear a discussion as to whether or not they want to schedule a preliminary hearing.
While we wait for that hearing to begin, let's go ahead and take a look at a backgrounder on this case. This is Court TV affiliate KSTU with a closer look at the suspect, Tyler Robinson.
Robinson had confessed to them or implied that he had committed the incident.
From his
Robinson had confessed to them or implied that he had committed the incident.
From his apartment to his family's home, the FBI police combed every inch of Tyler Robinson's life, his family expressing to law enforcement that he had become more political in the last few years.
Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Neighbors across the community were hurt, confused at what they called a quiet man turned to suspected political assassin.
I just learned a half hour ago, my son called me and said, "Did you know it was your neighbor?" I said, "No."
His neighbor said Robinson used to come over and help her mow her lawn when he was a kid.
Whenever I've needed anything, they've been able to come over and help very graciously and kindly.
So who is 22-year-old Tyler Robinson? We know he was raised in Washington, Utah. Yearbook photos show him in nearby Pineview High School. Robinson attended one semester at Utah State University, but never at Utah Valley, where the shooting happened. More recently, he was enrolled at Dixie Technical College. Administration confirmed in a news release that Robinson is a student in the electrical apprenticeship program.
I heard that he's from St. George, and I'm like, man, that's crazy. And then I see a picture of him, and I'm like, I know this guy. I've seen him. I'm pretty sure I went to school with him.
Carson Knight couldn't believe it as he realized Robinson was a classmate in that program.
What classes were you taking together?
We were taking residential electrical. And then I remember where he sat in comparison to me and seeing him every day. From what I remember, he sat by himself in the back of the class. So I don't remember everyone ever sitting next to him.
As our cameras were rolling on scene, the FBI focused a lot of attention on a shed at the back of the house. They also focused attention on the car, lifting the hood and eventually towing it. And as those around the home try to make sense of all of this, they're also praising the bravery of the Robinson family and friends for speaking up and turning him in.
That they did the right thing and justice will be served.
Why don't we go ahead and bring in our guest this hour to discuss as we wait for that court appearance to begin out there in Utah. Joining us now from Los Angeles, California, former Deputy Public Defender for LA County, Philip Dubé. Philip, nice to see you on this Monday. Thank you for being with us. All right, we are waiting to see what's going to happen out there in Utah. He has newly appointed counsel, the 22-year-old man, and we'll have to see if they decide they want to waive their right to a preliminary hearing. We're waiting the start of it. Philip, what are you thinking we're going to see?
I think the first thing that's going to happen is counsel is going to be appointed on behalf of the young man. They're going to accept the discovery and probably check to see whether purposed. Just because counsel is appointed doesn't mean they can take the case. So assuming the conflict check hasn't been run, that's what they're going to do. I suspect that whoever accepts appointment in the case is not going to set it straight ahead for preliminary hearing. They're going to need time to really prepare this thing. So they're going to waive time, ask for a continuance, put it over for conflict check, and to work it up for prelim. And you never know, they might even try to work it up for a disposition to take death off the table.
And Philip, you know, for our friends on the other side of the pond that watch us and don't have the same court system, or new people that are just joining us at Court TV, what is a preliminary hearing?
Yeah, the purpose of a preliminary hearing is where a judge listens to the evidence put on by the prosecution solely to decide whether or not a defendant charged with a crime should even stand trial.
Let's go ahead.
Court has to find probable cause.
The judge has taken the bench, Philip. So why don't we go ahead and see if we have audio in there?
Calling the case 251403576, State of Utah versus Tyler James Robinson. Counsel, could you enter your appearances, please?
Chad Grunander, Jeff Gray, Lauren Hunt, Ryan McBride, and Chris Ballard for the state, Your Honor.
Good morning, counsels.
Good morning, Your Honor. Kathy Nestor, Michael Burt, and Richard Novak on behalf of Mr. Robinson.
Good morning, Your Honor.
Good morning to you all.
Good morning.
Into the jail. Do we have Mr. Robinson present?
Yes, Your Honor.
All right. Mr. Robinson, good morning to you as well. Counsel, as we begin, I have entered orders allowing the admittance of Mr. Michael Burt, Mr. Richard Novak, pro hoc vice, and appointing them along with Ms. Catherine Nestor to be Mr. Robinson's counsel. The court enters findings that the combined experience of counsel meets and exceeds the requirements of Rule 8. Counsel, do we have, what would we like to accomplish today?
I have two items, Judge. I just wanted to make a record that under Rule 16 of the Utah Rules of Criminal Procedure with respect to discovery, the state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll look for defense counsel's request or the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process, so we'll be working together. There is a substantial amount of discovery in this case, Your Honor. It's voluminous, to say the least, and we're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend there was a protection order, pretrial, and trial publicity order entered by Your Honor. And I just was seeking some clarification. On page 2, at the end of the first paragraph, it reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front. But as they become known, I would ask that you would inform them of this. Anything else, counsel?
Nothing from the state. Nothing else, Judge.
Thank you. Ms. Nestor.
Thank you, Your Honor. We recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming, and until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing. Also, as far as a detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right. Now, as we're at the beginning, anything further from counsel from either side?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that it be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you. Counsel, anything else that we can address today?
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
Thank you, Your Honor.
And that concludes that hearing. Philip, let's go ahead and bring you in on this, listening to Kathy Nestor there, who has decades of experience in the legal field. She is going to be representing Tyler Robinson along with a number of other attorneys. We also heard from the prosecutor in the case, Chad Grunderson, and his team. Not surprising that the defense counsel gave an indication that they do not plan to waive a preliminary hearing, Philip.
Oh, yeah. No surprise at all. First of all, they don't even have all the evidence in their possession yet. They don't have a complete list of all the witnesses. But one thing I do like about the state of Utah, they have some pretty strict requirements to be appointed as capital defense counsel. First of all, you have to have at least 5 years experience as an attorney. Now, to most lawyers, that's not very much, but in the court-appointed cases where counsel is earning substantially less than you would get in the private sector, that's a decent amount of time. They also require that you have at least 6 felony jury trials as defense counsel and at least 1 murder, or a total of 25 trials, and that you've done at least 11 hours of teaching or receiving legal education after law school. So it's a pretty strict requirement. I'm not going to say it's a high bar, but the goal is to make sure that any capital defendant gets competent representation. And let me tell you, they've got a great team. They also require that you have at least 2 attorneys working on the case. One likely will be assigned to the guilt phase, and one will be for mitigation, working on everything that went wrong during this man's life to hopefully spare his life. But I like the trajectory of this team, and it seems like they know exactly what they're doing. The only criticism I have was that those closing words about how we're all here to seek justice, like the warriors of justice. Attorneys and judges don't speak that way in open court. It's presumed that everybody will act with integrity, with honor, and to articulate it on the record, in my opinion, is pandering to the cameras.
All right, Philip, so what we're looking at here is October 30th, 10 a.m. is the next court date. That's going to be yet another status hearing, so to speak. Defendant wishes to be present for that one. He was not today. He was not in his Zoom camera in view. He was in the jail during this hearing, but present. What do you make of the fact that the prosecutors are intending to seek the death penalty here? And do you think that that is also part of the reason why there's no rush to get to court for the next court date? It kind of, expands the timeline here, correct?
Of course. And the practical reality of it is that capital cases take at least 4 to 5 years to get to trial, if ever. They're the types of cases that really require an enormity of investigation, psychiatric workup, psychosocial workup, and certainly you want to be able to see if you need your own experts to review all the evidence independent of the prosecution's theory. So this is the kind of stuff that does not happen overnight. I don't believe that a prelim is going to happen in this case for at least 6 to 9 months. If it happens any sooner, it means that the issues are really not that complicated, and they'll be ready to go.